Welcome to Native America Calling. I'm Sean Spruce. A new federal lawsuit is taking aim at over 200,000 acres of land set aside for Native Hawaiians. The legal battle puts a century of hard-won victories by Native Hawaiians in serious jeopardy. It's one in a series of challenges against practices that specifically benefit Native Hawaiians who don't enjoy the same political status as Native Americans. Coming up, we'll break down the implications of this high-stakes suit. That's after the news.
This is National Native News. I'm Jill Freitas. Wildlife across southern southeast Alaska is emerging from wintertime hibernation. But in Metlakatla, on Annette Island, animals aren't the only thing waking up. Canoes are hitting the water again, marking this year's start of the Tsimshian tradition that's tied to the village's history. KRBD's Hunter Morrison tagged along for a recent canoe journey and has this story.
About a dozen people are holding cedar boughs in a driveway on the outskirts of town. David Nelson grabs his drum and begins singing. As the drum beats echo through the subdivision, it hasn't been performed in 3 years.
We believe they're like a living, breathing thing.
The ceremony marks the start of the canoe's spring and summertime journey. Johan Atkinson, president of the nonprofit Lawida, says the organization's goal is to share Tsimshian culture and bring Metlakatla back to its canoeing roots.
It's that feeling of we're going to be on the ocean of our ancestors, and that feeling is just so comforting.
The canoe is towed to a boat launch, from which they'll paddle to nearby One Tree Island. Atkinson hopes fun opportunities like these can help keep Tsimshian traditions alive for the next generation.
You know, having them experience now is something that many of us adults have not experienced at their age.
Atkinson says folks from all over the country visit Metlakatla each summer to experience the village's canoe journeys firsthand. Reporting in Metlakatla, I'm Hunter Morrison.
Robert Nick was a man of the Southwest Alaska tundra and so much more. He died last month at the age of 84. His memorial service was at St. Innocent Russian Orthodox Cathedral in Anchorage last week, whereas KMBA's Rhonda McBride tells us he was remembered for a lifetime of public service.
Robert Nick's Russian Orthodox service was fitting for a man who loved the harmonies of a Slavonic choir. For Andrew Guy, president of the Chilista Native Corporation, Nick represents the end of an era.
He's part of that group that came from having no electricity, no outboard, to where we are today.
Nick helped to bring electricity to villages throughout southwest Alaska through his work with the Alaska Village Electric Cooperative, an organization he helped found. Richard Jung, who owned Jung's Trading Post in the neighboring village of Napakiak, said Nick's leadership grew from the values he was raised in.
One of the things that you're taught is to help people. You try to do what you can for your village and your region, and he was one of those guys that did that.
Robert Nick was very proud that he was the first in his family to receive a Western education and graduate from high school. That achievement became a foundation for decades of service on boards and commissions that focused on a wide range of causes: health, education, housing. His niece, Karen Cook Phillips, says he was tireless.
Attending meetings after meetings and days and hours, and for continued years.
Nick dedicated many years of his life to improving housing conditions in rural Alaska. He also served on the Lower Kuskokwim School Board for 2 decades. Steve O'Brien, a former school principal, remembers giving Nick a copy of Robert's Rules of Order to help him.
He said, "Oh, I already have that book."
O'Brien says it's no surprise that Robert Nick eventually was asked to chair almost every board he served on. In 2014, he received an honorary Doctorate of Laws degree from the University of Alaska Fairbanks. In Anchorage, I'm Rhonda McBride.
And I'm Jill Freitas.
National Native News is produced by Koahnic Broadcast Corporation with funding by the Corporation for Public Broadcasting.
Alaska has Fresh Start programs to lose weight, lower blood sugar or blood pressure, stop smoking, vaping, or chewing tobacco. Many programs are no cost or low cost. Visit freshstart.alaska.gov to find the program that's right for you. This message is sponsored by the Alaska Department of Health.
Hear that? Tribal college faculty do so much, one can't say it all here. Nothing but respect. Visit mostthoroughdjobdescription.com. The American Indian College Fund supports this program.
Native Voice One, the Native American Radio Network.
This is Native America Calling. I'm Sean Spruce. A new legal challenge to a century-old law that helps Native Hawaiians lease land is alarming lawmakers, housing experts, and legal scholars. A non-native resident filed the lawsuit that challenges the Hawaiian Homes Commission Act approved by Congress in 1921. It offers a 99-year lease to Native Hawaiians as long as they can prove they have a 50% blood quantum. It is a form of reparations for the historic dispossession of land for Native Hawaiians who are increasingly priced out of their homeland and face high rates of homelessness. The plaintiff argues the law is unconstitutional because it discriminates based on race. The lawsuit jeopardizes Native Hawaiians' ability to address land dispossession and forces them to reevaluate their legal claim to blood quantum as a form of identity. Today on our show, we'll speak with Native Hawaiian homesteaders and legal experts about the implications of this lawsuit. Listeners can join us with comments and questions. Call 1-800-996-2848. 1-800-996-2848. Joining us now on Zoom while traveling in eastern Oklahoma is Robin Danner. She is the Senior Advisor to the Sovereign Council of Hawaiian Homestead Associations, and she is Native Hawaiian. Robin, welcome to Native America Calling.
Aloha, mahalo for having me.
Aloha to you as well. Also joining us on Zoom from Honolulu, Hawaii, is Elizabeth Ho'oipo Panakea. She is the attorney and founding president of Hui Na'auau and executive director of the Native Hawaiian Advisory Council. She is also Native Hawaiian. Elizabeth, good morning and welcome to Native America Calling.
Mahalo, Sean. Aloha kakahiaka.
Mahalo to you as well. And our third guest joins us from Hilo, Hawaii. We have Patrick Kahavrai Ola'a. He is a homesteader and an elder, and he is also Native Hawaiian. Pat, good morning, and welcome to Native America Calling to you also.
Aloha, aloha, kako.
Aloha to everyone again. And Robin, I'm going to begin with you today. The Homes Commission Act of 1921 that we just mentioned in the intro, it establishes trust land specifically for Native Hawaiians, and it's a very unique process in how it does that. Can you explain to our listeners how it works?
The bottom line is the Hawaiian Homes Commission Act, enacted in 1920 and then in 1921, it happened 14 years after the 1906 Indian Allotment Act. And they very much align, the Hawaiian Homes Commission Act aligns during that federal policy era to establish trust lands for the three non-immigrant indigenous populations, which were and are American Indians, Alaska Natives in the 49th state, and Native Hawaiians in the 50th state. And so the Hawaiian Homes Commission Act, while we as Hawaiians might want to say it's unique, it really isn't. The content of the Hawaiian Homes Commission Act, basically, Jonah Kuhio Kalaniana Ole, the congressman from the territory of Hawaii at that time, said, give my people land for housing, give my people land to grow food for farms, give my people land to grow livestock, pastoral lots, and give my people land for commerce, for economic development. And all four of those things, Sean, are contained in the 1906 Indian Allotment Acts and the many, many other allotment acts over the decades, when our country was trying to deal with what do we do with the people who are already here in the 48 states, in the 49th state, and in the 50th state. And so the Hawaiian Homes Commission Act at at its essence is an allotment act. The reason why there are leases, as you may know, is during that era there was trouble in Indian country with carpetbaggers coming and using the allotment acts to, I will say, take and steal Indian land. And so a new policy era came into effect, which was long-term leases. And so we came onto the scene in that way. And then finally, Sean, I would say to your listeners that there are 3 Native groups, and Native Hawaiians are the youngest sibling. American Indians got contact 500 years ago. Next, they went north, from the eastern seaboard to the west, and then they went up to Alaska. And then in about 50 years after Alaska, they went out to the Pacific, to Hawaii. And so it was all part of the Manifest Destiny policy of the federal government a century ago. And that's the genesis. That is the genealogy, really, of the Hawaiian Homes Commission Act. It wasn't a one-off. It was a continual policy, federal Indian policy around trust lands. And so we today have about 203,000 acres on each of the islands, and the Congress enacted it with a blood quantum. It should be understood. And we have a wonderful elder with us, Uncle Pat, that the initial approach to the Hawaiian Homes Commission Act was practically no blood quantum, 1/32 blood quantum. It was their definition of quantifying Native Hawaiian. Jonah Kuhio Kalaniana Ole, the congressman, he wanted 1/32. The plantation owners who opposed an Indian Allotment Act or an allotment of land to set aside, they wanted 100% blood quantum, because they believed that, within a generation, they would get that land back and they could take it again, take the 203,000 acres. And so we have a 50% blood quantum, not by our standards, but by the congressional process that split the baby and made the blood quantum 50%, which we have lived with for the last century.
Okay. Robin, you mentioned the comparison between tribal governments for Native Americans, homestead and beneficiary associations in Hawaii. These 200,000 acres, just so we can clarify for our listeners, these are not trust allotments like we would have here with Native American tribes in the United States, or are they, just to clarify?
Sure, they are. We can go down a legal rabbit hole, but basically Congress set aside 200,000 acres and said, issue lots of land, allotments of land to Native Hawaiians to build so that they can build their homes, they can operate a farm, a ranch, or businesses. And so Elizabeth, Uncle Pat, myself, we are all eligibly enrolled under the Hawaiian Homes Commission Act, and for an allotment for either a home, a ranch, or farm. Does that help? So the act even, Sean, defines the minimum amount of acreage for a home, for a ranch, and the maximum as well. Does that help?
It does help. I'm just trying to make a comparison for listeners who might be trying to determine how these are different than from what we think of as a reservation here in other parts of the country that has a specific trust responsibility through the federal government. That's the only clarification.
So you should think about, these are not tribal government or reservation. These are allotments. So Indian country has tribal lands that are that the tribe controls. And aside from that, the Department of Interior issued allotments directly. And then over time, tribes have become very much involved in that process, thank goodness for that. I will say one further thing for your listeners. So the federal government has a trust responsibility to us as articulated in the Hawaiian Homes Commission Act and as articulated in well over 150 other congressional laws. So we have a Department of Interior agency that is responsible for that trust responsibility. But in 1959, as Uncle Pat and Elizabeth well know, the Congress did an experiment with us. They added the state of Hawaii. So we are a condition of statehood in Hawaii. The Statehood Act that Congress passed basically said, hey, we'll let you be the 50th state, but you must administer the Hawaiian Homes Commission Act on our behalf. And so what that does, Sean, it sets us up to have two BIAs, if you will. One at the federal level and then one at state government. And the way that I like to explain to Indian country, just imagine if Navajo Nation had to go to the state of Arizona to get approval for what they wanted to do on their land. Your heads would blow up. But we have weathered this and dealt with the cards that have been dealt us, which is a double whammy, a federal agency and a state agency.
Robin Danner. Okay, Robin, that's awesome. Yeah, thank you so much. That's really helpful background information, really helps frame this topic for our listeners. We're going to take a short break. We're going to come back. We'll continue our conversation with Robin Danner and our other guests. And we have the phone lines open for listeners who would also like to join the conversation today. You can call us at 1-800-996-2848. You can share your thoughts or ask a question of one of our guests. Again, we were talking about a challenge to the Hawaiian Homes Commission Act, which was approved by Congress in 1921. And we heard from Robin Danner, Senior Advisor of the Sovereign Council of Hawaiian Homestead Associations, just how this law has worked for Native Hawaiian people going back over 100 years. And there are similarities to what we have here with Native American tribes, but also in other ways, it is not exactly the same type of situation. A little bit of an apples to oranges comparison in some ways, but in other ways, very similar. So join the conversation if you would like to share some of your perspectives as well. 1-800-99-NATIVE.
Good job, Robin.
Tribes along the Columbia River say decades of dredging damages habitat for dwindling salmon runs and other cultural resources. Their concerns come as the Army Corps of Engineers is finalizing plans to make room for bigger shipping barges in the Pacific Northwest's largest river. We'll find out more on the next Native America Calling.
Grand Canyon Conservancy fosters visitor engagement with the landscape through learning, discovery, and stewardship. The Grand Canyon Conservancy Field Institute provides immersive and educational adventures designed in partnership with Grand Canyon National Park, including day hikes for the family, once-in-a-lifetime backpacking trips, and art classes with expert instructors. More at grandcanyon.org. Grand Canyon Conservancy supports this show.
Thank you for listening to Native America Calling. I'm Sean Spruce, and we're speaking with Native housing and legal experts about a new lawsuit that challenges a law that grants land access to Native Hawaiians. You can join today's conversation with comments or questions by calling 1-800-996-2848. That number is also 1-800-99-NATIVE, and you can also continue the conversation on our website, nativeamericacalling.com, and our social media platforms such as Facebook, Instagram, Blue Sky, and Threads. Our next guest joins us now from Honolulu, Hawaii, Elizabeth Ho'oipopanakea, who is the Executive Director of the Native Hawaiian Advisory Council. And Elizabeth, we heard from Robin earlier describe the blood quantum requirement here for getting one of these leases for land through the Homestead Act. And the plaintiff argues now that the Homes Commission Act is unconstitutional because it offers preference based on race. And we've covered this topic numerous times here on our show with similar race-based preferences where they have fallen in other areas of the country, and this has become a recurring pattern over the last few years. I want to ask you now, how is this different, though, than race preference cases that are being overturned elsewhere?
Okay, mahalo, Sean. To understand this lawsuit, you have to look past the misinformation. The Hawaiian Homes Lands Trust is the foundational contract of our statehood, as Robin just said. It's a non-negotiable agreement. It was made in 1959 to protect the land rights of the indigenous people of Hawaii after that history that she shared with you. It's a strict historical and political relationship. The lawsuit we're seeing today is an attempt to breach that statehood contract and liquidate the 200,000 acres of land that was never meant to be on the open market. Because of the government's massive fiduciary failures here, our people have been trapped on wait lists for decades. That's like the three of us. As time passes, blood quantum naturally dilutes. This is why the state of Hawaii passed Act 80, so our descendants aren't mathematically disinherited. So that lowered the quantum to the 132nd, but that's been sitting on the shelves at the federal government. The state passed that. The Pacific Legal Foundation, which is backing up Eric, is bypassing that democratic fix and trying to use a colonial metric as a kill switch to blow up the entire trust. But we aren't just looking at a legal theory here. We are looking at the liquidation of land right out from under the families we are fighting for. And that is why we're having Robin Danner with us is so vital. It's not just the families on the wait list, it's the current homesteaders struggling for water, dealing with inadequate roads, and fighting legal loopholes that deny them basic services, especially in the wake of storm drainage like the recent Kona lows on Molokai, for example, and these devastated homesteads across the islands. For these families, this isn't a legal dispute, it's a battle for the basic survival, for the water in their pipes and the road to their front door.
Okay, thank you, Elizabeth. Now, Native Hawaiians do not share federal recognition like Alaska Natives and Native Americans do. And I really liked Robin's analogy with regard to the siblings, the youngest siblings, the middle siblings, the older siblings. But you do argue that Native Hawaiians are a protected political class. And I'm interested to know how difficult it is to prove that without any formal connection to federal recognition.
Well, there was a recent solicitor's opinion that was filed, and it documented that we do indeed have a government-to-government relationship, and we have been recognized, as Robin also mentioned, many times in the law. And it's just that right now the Trump administration is burying that solicitor's opinion right now as we speak. So that already acknowledged our recognition, and basically it was just that we need to unite on the wording of our Constitution, which we have taken some attempts to do, but we have diversity in our group. So we're trying to unite on that, and hopefully we can complete that soon to have the armor we need to withstand these attacks.
Sean,
yeah, please do, Robin.
I would push back a little bit. We are federally recognized. There are two prongs to federal recognition in the federal policy that's a couple 100 years old. The first prong is, are you federally recognized as beyond race, as a political body, as Elizabeth mentioned? And the answer to that question is yes. Native Hawaiians have been federally recognized as beyond race, as an indigenous population with a political relationship with the federal government. That has been affirmed over 150 times in congressional statutes. The second prong of federal recognition is for a Native people themselves, not the federal government to do it to us, but for a Native people themselves to then apply for that government to government relationship. That's the second prong.
Okay.
And right now, that is not something the federal government does to us or does to, the Lumbee or does to Navajo or any other. That is something that those Native peoples, including us, make a decision to pursue. And we have that option to pursue. And we're going to take our time in doing that, as Elizabeth explained. So I would push back a little bit that Native Hawaiians are just the youngest sibling. We are federally recognized as an indigenous group that is beyond race. And I think that's the mistake of Mr. Ryan and the other lawsuits, is they are trying to cubbyhole us Native people as race. And we are not. We are beyond. American Indians, Alaska Natives, and Native Hawaiians are beyond race. We're in the U.S. Constitution.
But Robin, let me just ask this, though, because some listeners might be saying, okay, well, what about the tribal government then? What about the government-to-government relationship that you have with Native American tribes in Alaska, Native communities in which there's an actual tribal government that has a direct government-to-government relationship with the federal government? They might be asking, why? Where is that in the Native Hawaiian equation?
It's the same place where the 60-some-odd American Indian groups are that are traversing the path and making the choice to seek federal recognition on the government-to-government relationship. We're no different. On homesteads particularly, we have been governing ourselves, whether the state recognizes it or whether the federal government recognizes it. We have been governing ourselves through what we call, not tribes, we don't use that vocabulary, but it essentially is the same. We have been self-governing through our homestead associations, which there are 55 of them across the Pai'aina, across the state of Hawaii, that have been operating for a century of self-governance, governing ourselves, making our rules, and passing on our our knowledge and our cultural ways of being. So just because the colonizer does not say it or want to see it or wants to make it invisible does not make it so. Same for American Indians and Alaska Natives. Just because the colonizer does not embrace everything that we are doing for ourselves doesn't mean we are not self-governing and and applying self-determination.
All right. Thank you, Robin. Also, thank you, Elizabeth. I want to bring Patrick into our conversation now. Patrick, you live on a homestead. You're on your homestead right now. Tell us about your land.
Well, right now I live on what is considered agricultural, an agricultural lot. I am able to build a home. Just to digress a little, when first given, I am a successor to my mother's original lease in 1934. She passed in 50. My dad got it in 55. These are all during the territory. Statehood wasn't until 1959. I was born in 1944 in the territory of Hawaii. And since then, I've decided to move to the agricultural lot. The Act clearly says, as it moves through the processes, there was an opportunity, as Robin did articulate, that Prince Kuhio, our territorial senator, representative at that time in the United States Congress from 1902 till 2022, prior to his passing, clearly, as the act was being created, said that these were as provisions of being able to acquire these trust lands, which were then part of crown lands. And that's the history our people do. And this was taught to me by Kupuna in the 80s, that when I was in my 20s, 30s, that we never need to forget that an overthrow happened, that our monarchical government was overthrown. So if you understand that, and because clearly the United States in 1993, President Clinton apologized for taking 1.8 million acres of land. That's the apology bill that you hear a lot of our younger aspiring Native Hawaiian lawyers and or those that believe in truly regaining our sovereignty, which Queen Liliuokalani never advocated, never gave up. She just made sure that the United States government was going to take care of the lands until the sovereign nations of Hawaii were restored. That's all explained in the admissions. In the apology bill. But for me, it was you qualified. You need to go. The first thing we needed to do was stand before a qualifications board. Bring your birth certificates and every piece of paper, every legal government document that Native Hawaiians had no involvement in creating. Again, territory was there was a census taker, I'm assuming, that went around and got the Native Hawaiians to say, hey, look, this is who you are. The percentage of Hawaiians was just, the word was either you're a Hawaiian or non-native. You're either Caucasian or whatever other race you wanted to say that you were. So those were the processes that we needed to use to get to the land. And it was, you had a residential, an acre. You could get 40 acres of agricultural land in close proximity, which meant you could have had a home on an acre, and 40 acres to now subsist, take care of your family get back to the soil, work the land, because we were already disenfranchised right at the overthrow, 1893. And Kuhio saw his people. And when I say his people, Kuhio was a member of the monarchy, but legally, democratically elected to represent the people of the territory of Hawaii after the Organic Act was implemented. So those are the kinds of things that we need to, if we understand that train of thought, then we can find out, because, and the act clearly in 1920 when it was created, Kuhio made sure that you could have a place for residents. He took us out of the tenement buildings. I'm sorry. We were at what is maybe Kuhio Park Terrace, Palama Settlement, those kinds of places back in the 20s, where public housing, because we were again disenfranchised from the land. He took us out of those types of environment and then put us to where we're at today. Thank you.
Thank you, Patrick. I understand that 3 of your children are still waiting on their leases. What is the status of those homestead claims?
They're still they're qualified. They got all their documents in. It's just that the state of Hawaii has seen fit for the last 30 some odd years. My children are part of this number that keeps growing. 30 years ago, it probably was 17,000 on the wait list. Now, at 30 years later, it's 30,000 on the wait list, and it's going to grow. Hawaiians are not going to disappear. They're here. They're here. It's just, but I do have 3 that are waiting on the wait list. So,
Patrick, you challenged the state of Hawaii for not following the law. For example, you sued the water department, and you didn't have to pay a water bill. What spurred that lawsuit?
Well, that lawsuit was there is, to understand the state of Hawaii, or in the time of the territory, when Kuhio created this act and Congress passed it and codified it into law in 1921, we sued to protect the evidence of fraud. We believe there was an evidence of fraud. We Native Hawaiians, and there were 12 of us that thought that there was a fraud. And the fraud was just this. As homeowners on our lease lands, we provided the water line from the house to the road. Okay. Then the government provided the water line from the well to our homes. Well, we believe that the county of Hawaii committed fraud by putting their water meter in between those things that were supposedly ours, based on the act, and what each lessee had to, that I paid for getting from my house to the road, and therefore the meter was then the fraud. Somebody's collecting money. That's an encumbrance on our lands that's put there by other people not in charge of the act. And that's clearly language in Constitution and in the compact that says encumbrance to be placed upon the land cannot be done by people not in charge of the act. So we made that argument, and the argument was it was not upheld. The decision wasn't made, but we got charged for obstruction of government operations.
Okay, Patrick, we're going to have to take a short break. We'll come back and continue our conversation. Stay with us, folks.
Support from Davis Keelan Law Firm, a New Mexico firm standing with Native families suffering catastrophic loss. When tragedy strikes Indian country, Davis Keelan fights to restore stability, dignity, and justice, bringing a voice to Native families and communities for 20 years. More information, daviskeelan.com.
Kaufman & Associates has over 35 years of experience serving Indian country, supporting growth, transformation, and sustainability of tribal programs. More at kaufmaninc.com, KAUFFMANINC.com.
We're glad you're listening today to Native America Calling. I'm Sean Spruce, and we're going to finish up our discussion about a lawsuit that challenges the Hawaiian Homes Commission Act of 1921. A reminder, listeners, you can tune into this show and all past shows on our website, nativeamericacalling.com, and all major podcast platforms. I want to go ahead now and play part of an interview with another person who is an expert on our subject today, Derek Kauanoi. He is an assistant law professor at the University of Hawaii, Manoa, and he spoke with producer Sol Traverso about the history of Hawaiian Homes Commission Act and challenges with the lawsuit.
We've seen other cases like the United States Supreme Court 2000 case or decision, Rice v. Cayetano, which is different in the sense that in that context, we're dealing with a state law that limited who could vote in elections for the Office of Hawaiian Affairs trustees. Here, though, we're dealing with congressional legislation that was passed by Congress and treating, to a limited degree, Native Hawaiians similar to American Indians. And so I think it'll be interesting to see how those are dealt with. I took a very cursory look at the legal complaint that was filed, and as can be expected, there's no recognition in that complaint about the unique political relationship that Native Hawaiians under the Hawaiian Homes Commission Act has with the United States.
We talked earlier about the Dawes Act, how the Homes Commission Act happened during the same time. Can you talk about the parallels there between the Dawes Act and fight to protect Hawaii's lands?
Sure. Yeah. So I think the Dawes Act and that policy era in general provides a context for understanding, even though Hawaii is, thousands of miles away from the West Coast, it provides a context for understanding those specific policies, the Hawaiian Homes Commission Act. But, in general, with the Dawes Act passing in 1887, it ushers in the policies of allotment and assimilation. And so, on the continent, what that meant was that Congress started to break apart tribal communal land holdings or reservations. And by doing that, by allotting individual parcels to heads of households. And, so-called surplus lands were then often sold to non-Indians. And from 1887 until the passage of the Indian Reorganization Act, you've got this loss of lands, these lands that leave tribal ownership into non-Indian ownership. And, that loss happens through a number of ways. But I think that, again, that provides an important context for understanding the Hawaiian Homes Commission Act. And I will say that there's a bit of nuance. As I mentioned earlier, what became the Hawaiian Homes Commission Act of 1920 changed a bit from what it originated from within the territory of Hawaii legislature. But by the time it goes to Congress, you have lobbyists and advocates for plantation owners who in Hawaii, they had long-term leases that were getting ready to expire, and that was coinciding with the passage of the Hawaiian Homes Commission Act. So now you had non-Native Hawaiian plantation operators who were also operating on leased lands who are now getting worried that, hey, our leases are expiring at the same time that this Hawaiian Homes Commission Act is getting ready to pass. And that Hawaiian Homes Commission Act is going to give 99-year leases to Native Hawaiians. And so, through that process, you end up getting this limitation based on blood quantum that gets imposed. Native Hawaiian leadership, their goal was that Native Hawaiians of 1/32nd blood quantum. So basically, what they had envisioned was determination or eligibility being based on descendancy, not necessarily on blood quantum. It ends up being a compromise in order to get the Hawaiian Homes Commission Act passed, that they settle on a 50% blood quantum.
That was law professor Derek Kauanoi giving historical background on the Hawaiian Homes Commission Act. And I want to bring Elizabeth back into the conversation because, Elizabeth, in a Honolulu Civil Beat opinion article, you stated that this lawsuit against the Hawaiian Homes Commission Act, alleging that it is, it makes decisions based on a racial preference, and there's pushback against that. You see this as a coordinated attack on Native Hawaiians, and I want to know what you see is at stake here in not just Hawaii, but also beyond Hawaii.
Well, I think this is basically a Trojan horse type of lawsuit that they're looking to come after us, but I think they're also going to be coming after you all, and that's why we have to become a united front on this. Like was said, Prince Kuhio proposed the 1/32nd requirement. The 50% rule was forced by the exact same corporation, sugar and ranching cartels that backed the 1893 overthrow. It's designed as a cynical compromise to hoard the land. And as the professor said, Kauanoi, this is a replay of the 1887 Dawes Act, right? Back then, the government used blood quantum and competency tests to erase Native identity on paper, declare 90 million acres of reservation land surplus, and sell it to corporate buyers, the non-Indians. And now the Pacific Legal Foundation is using the exact same legal trick today. They are weaponizing a fractional metric to erase our legal status as sovereign people, hoping to declare our 200-acre trust invalid so they can force it onto the open market. And the math hasn't changed and the motive hasn't changed. It is a manufactured legal mechanism to liquidate indigenous land, ours, and I think they're going to come after Native Indian country too. So it'll be good for us to unite and start calling our congressional delegates on this matter.
Elizabeth, you say the math hasn't changed, but in a sense, I think the math has changed because I think we all know that property values in Hawaii are just going higher and higher, and so many people are now priced out of home ownership, and sadly, many Native Hawaiian people are as well. And I want to go back to Patrick and ask you, Patrick, I mean, I imagine a lot has changed in Hawaii since your parents' time, and what are you noticing about how valued the property is there and how land is being bought up so rapidly?
It is. Yes, I've seen a lot. I left and joined the military in 1963. I enlisted in the Navy and left for about 25 years. Had my family, met a girl from the homestead. Fortunately, I met a girl from the homestead. She was living in Los Angeles. We got together, married, had my 3 children. And in 1979, moved back. I had bought a home in Los Angeles through the VA. Even California then was not, as the prices of land as it is now. But in Hawaii, to equate our trust lands to those lands, when you priced out of Hawaii, we're not priced out of the land. We're priced out of the building. On the cost to build the structure, that's where the cost is for me and for my children. My oldest daughter right now is to get a loan to build a home that's going to cost right now building materials and permitting and all of those insurance, everything is going to be in excess of $550,000 here on the island of Hawaii, where the AIM is lower than any other county out of the 4 counties in the state. So yes, the cost to build a home is it's becoming ridiculous. But we can look at the Jones Act. We can look at everything else why it becomes a hindrance. But I have to believe that our people, when I say our people, our Wākahiko, our ancestors, look at some of the homes that we built, that they built, that's still in excuse me, you people can look into it as into the museum, how they built. If we were giving some ways to do that, using the natural abundance that are there, well, we've lost a lot of our forests, so we don't have the trees that we would have. Our sandalwoods was taken, our core was taken. So the price of living in Hawaii, yes, has gone up exponentially all over.
Right. Thank you,
Patrick. It's because of building a home as opposed to having the land.
Okay. The cost of construction. Sure. Robin, back to you, because I'm thinking of people who could be tuning in right now and they're hearing about this issue, and especially the waiting list and how long it is. 30,000 Native Hawaiians waiting to realize these leases, and they're probably just asking themselves, is there a better way to distribute this land? And I'd like to get your perspective, Robin. What do you think? What could be a better way to make this act work better for the Native Hawaiian people who it's intended to benefit?
Well, the best answer to that is to have a state government that raises their right hand and promises to implement the state of Hawaii Constitution, which includes the Hawaiian Homes Commission Act, to do it. Uncle Pat talks about, and he's correct, that the vertical cost is prohibitive. But okay, that's not the barrier to getting 30,000 people off the wait list. They aren't due a home. They are due an allotment. And I would say that the better way is to have governors, and we've had governor after governor after governor, 9 of them, to have a loyalty, to raise that right hand and understand and read the section of their own constitution, the Hawaii State Constitution, that says follow the Hawaiian Homes Commission Act, issue those 30,000 people an allotment of land. Don't try to do all kinds of off-ramps and tricky stuff like lease to own or rental housing. We need a state governor. We need state legislature that all raise their right hand to promise to implement the Constitution, to give my people their allotment for a house, for a farm, for a ranch, and for mercantile. It's just a simple duty of loyalty. And you know, Sean, that I'm not speaking out of school, because American Indians and Alaska Natives have traveled this path, have traversed this question that you ask, and over the decades, they have implemented tribal consultation. They have implemented for the federal government better ways of implementing what the federal obligation to them is. And we expect nothing less. We would like a governor and a legislature to embrace the promise they made in 1959 to become the 50th state, to welcome all the economic prosperity that has resulted from that statehood, and turn around and start issuing land. Uncle Pat is not asking for a house. Elizabeth is not asking for a house on the wait list. I am not asking for a farmhouse on as I sit on the wait list. I am waiting. 30,000 50% blood quantum Hawaiians are waiting for the issuance of a piece of land. And if they could do that duty, Sean, the world would change, because we are not a stupid people. We are resilient. We are intelligent. You give me that piece of land and we will do something with it. We will figure it out, even with the challenges that Uncle Pat eloquently and clearly stated about vertical construction. And I just want to say one last thing, that things have changed, yes, and you point out that the value of our land has skyrocketed. And so that only makes the one thing that has never changed about colonizing American Indians, Alaska Natives, and Native Hawaiians, and that is coveting that which is not theirs. It is ours. It will always be ours. Hawaii will always be our homeland, as Alaska will always be Alaska Native homelands, as the 34 other states where trust lands and tribal governments exist in the 48 states will always be there. And so that's the one thing that has not changed, and we will fight. We will fight for our right, for our homelands, because that is what our ancestors expect us to do, and we will do it, Mr. Ryan.
All right, Robin Danner, bringing it home here on Native America Calling. We have about a minute and a half before we have to wrap up. Elizabeth, I want to give you the last word here, because you're compiling a list of all the Native Hawaiian specific programs that are under threat right now. Tell us about some of these programs and what you see can be done to defend them right now.
It's just about every program that ever was. It's the education programs. It's our SNAP food stamps. It's the prevention programs for women. It's the preventative health. It's the any ANA funds. It's the health programs. It's the Kamehameha schools. I mean, they are going after everything. There's a big list, and it's at least 12 programs. Anything that has Native Hawaiian on it seems to be on the chopping block.
And with that, we are out of time, so we're going to wrap up the show. I want to thank all of our guests who joined the conversation. We had Robin Danner. We had Elizabeth Ho'oipo Panakea. We had Derek Kanoa-Awanoi, and also Patrick Kahavra Ola'a. Join us again tomorrow for a look at the environmental effects of dredging on the Columbia River. Until then, I'm your host, Sean Spruce. Enjoy the rest of your day.
Hello.
colleges and universities support their students in countless ways. They say I believe and offer help before it's asked.
Hear that? That's everything tribal college faculty do for their students on Fast Forward. Because if one tried to say it in real time, they'd be here all day. They teach, guide, comfort, and connect. And for that, the community is grateful. Learn more at mostthoroughdjobdescription.com. The American Indian College Fund supports this program.
They give extensions, cheer progress, share laughter, create calm, and allow reflection. They inspire hope, share wisdom, guide gently, validate feelings.
Who protects Indian country? Ameren does. As the only 100% tribally owned insurance carrier, Ameren helps strengthen tribal communities by providing reliable insurance coverage and keeping dollars in Indian country. From property and liability to commercial auto and tribal workers' compensation, Ameren is here to protect what matters. Celebrating 40 years of serving Indian country. Learn more at Ameren.com. That's AMERIND.com.
Native America Calling is produced in the Annenberg National Native Voice Studios in Albuquerque, New Mexico by Koahnic Broadcast Corporation, a Native nonprofit media organization. Funding is provided by the Corporation for Public Broadcasting with support from the Public Radio Satellite Service. Music is by Brent Michael Davids. Native Voice One, the Native American Radio Network.